Hello, everybody, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd, and today is Tuesday, August 23rd, 2022. It's actually the day after my wedding anniversary. Yippee. uh, sorry, I had to go there. Welcome to the show. Catch us, the Fearless Floyd Show on Telegram, TheFearlessFloydShow.com. I'm also on BitChute, Rumble, as well as YouTube, which you're probably watching here because it has the biggest audience. If you like me, my channel, my topic, my guests, anything, hit that like button. Leave a comment below. Subscribe to the channel. If you like these videos, like the topic, like the genre, hit that notification bell if you want to know when I put out new videos, like I'm going to do today, and share this video with God and everybody. Thank you for being here. I appreciate it. I have a special guest, Ann LeFlore, and we're going to do a multi-part series on trusts and how to operate your trust. This is a PowerPoint presentation. This is part one. Ann estimates that it's going to be right around 6 parts. Don't hold me to that. You'll see it in the thumbnail, and the description will tell you which part and how many parts the total series is going to be. So keep your eye out for that. She should be close to joining us. I've already sent her the link. So I'm just waiting her to catch up and get with us. Man, these are going quick. Hey. All right, kids, so we are back with Ann LeFlore, and I'm going to let her take the floor, and I am going to run the PowerPoint presentation. So bear with us if this is a little wonky, because she's doing the narration. I haven't even looked at the PowerPoint, to be honest with you. So I'm going to learn just like everybody else. Okay, let me pull it up, share screen. Okay. And I'm going to minimize ours. All right. Trust part one, how they work and operate. And by the way, thank you and bless you for taking the time to put this together. I mean, you did this.
Oh, you're so welcome.
Yeah, you did this on your own volition. Nobody asked you to do it.
No.
Yeah, I mean, you just, okay, I want to do it, and did it. So here you go, kids.
Well, everybody needs to understand how everything is operating right now and how simple things can be if they just understand trust law and how everything is a trust. Everything we do on a daily basis is a trust. So if we look at what it says under trust, which would be the first slide.
Oh, okay. Let's see if I did not screw that up. Let me go back. I opened it up to be edited, so it didn't like that.
You might have to go into view mode, and then you can do it in full screen view mode, which is easier just to flip through it.
Okay, well, I can increase the size.
In view mode, yeah, that's better.
Okay. All right, trust part one.
Okay, so here we can see that trusts are basically a combination of different elements that form the trust. It's a very simple situation. If you have different elements and you combine them together, you're forming a trust. For example, if you go to the gas station and you're paying gas and you give the money, this is a trust because you're giving a promissory note to pay something. So you've created a trust. Everything we do on a daily basis is a trust because there is no money. Money was taken away in 1933. And in that period, and when they did that, everything was put into trust. So everything we do is formed on trust.
Okay. For those of you who don't have the ability to look at your screen, but like to listen while you're working out or gardening or whatever on your earbuds or headphones, I'm going to read this. The word trust refers to the duty or combining several separate elements of obligations that rest upon a person described as trustee. The responsibilities are in relation to property held by him or under his control. That property he will be compelled by a court.
I'll tell you what it says.
Hang on one second.
Here's what it said.
Woody, what?
Well, okay, it's dog. I gotta go outside and get thrown at.
Thank you. I have a guest here and he knows I'm shooting a video and he has his
Well,
earphone.
we might have dogs barking on my side if the dog's in the
Yeah,
river.
well, he knows better. Okay. That property, he will be compelled by a court in its equitable jurisdiction to administer in the manner lawfully prescribed by the trust instrument, or where there be no specific provision, written or oral, or to the extent that such provision is invalid or lacking in accordance with equitable principles. Did you like steal this from, or borrow it rather, from Black's Law or Bouvier's or something like that?
No, actually, I took it out of a trust book.
Okay.
I went directly to trust and I started studying trust and I went directly into trust law. And this is the law of trust. And this is what the law says and what the legal definition of trust is by law. Black's dictionary has a different definition than what this is. But this deals with the simple fact that if you do not stand up and say that you have a trust and you're not expressing your trust, they have the authority to create the trust for you and assign you as the trustee. So it's a written or an oral obligation in every adventure that you do to create trust.
Okay, can you give the title and author of that book? So somebody else.
I think it was through Oxford. It was in Oxford Law Dictionary and Oxford Law.
Okay.
And this is where I found it. And also, if you went into some of the other law offices or law dictionaries, the wording and verbiage was almost the same in every situation I looked at. And the books out there that teach trust, the verbiage is very similar in all the books. And I think I went through 8 or 9 books, you know, researching trust and how trusts work to see if there was a difference between the verbiage, how one person taught it, how another person taught it, what the true meaning of trust was and how it was applied to law and how it's applied to us on a daily basis.
Okay. So Black's Law was like similar, but definitely not the same or close.
It was kind of close. Black's Law breaks it down into all different kinds of things, and so do some other law dictionaries. But one I did find that was really good was a dictionary that literally is online that you can look up any words that you want on it. And it's from a law firm, and it had like the best definitions, the best presentation of all the different types of trusts there were out there. And I really like that one the best.
Okay. Yeah, I've run into that before with Black's Law that, plus they change it constantly.
Yeah, it's kind of hard.
Yeah. That's why everybody kind of uses the 6th edition as the springboard to go from. Okay. Moving on to panel number 3. And this is the nature of the trust. For some reason.
No, it's up one more. You have to go back up. Yeah. So when we create trust have to have an intent. So what is our intent? Our intent is to push out there that we are going to create a trust. That's our intent. Specific trust res, that means that it's a thing. It doesn't mean that it has a value. So anything that you want, you can put it into a trust. So as long as it's a thing and you can identify the thing, it can be put directly into the trust. Then we have to identify, the properties and who are the parties of the trust. So we do know there's 3 parties in the trust. So that's part of the trust. And then, and what is the valid purpose of the trust? The valid purpose of the trust is what we intend to do with the trust and how we intend to use the trust. If we're going to use it as the grantor, or we're going to use it as the beneficiary, or we're going to use it as the trustee. It depends on us because we are the grantor of the trust. Every time we sign anything, we're the grantor of that trust. Our signature creates a trust every time we sign a document.
Okay. And panel number 4. Let me just click on it. There we go.
So under trust, we do not give anything as a value. Everything we put in the trust is called a res, R-E-S. And what a res means is it means anything that we can physically move into the trust. So we can consider our birth certificate a res because it's a document, it's a signed document, it's under seal. It has no value because it's a piece of paper. We can move any court documents or any offers that we receive in the mail. So when we look at documents and we look at offers, those are considered res. So if you have a credit card contract and you signed a credit card contract and you receive a bill from the credit card company, that is a res, an RES, and that can be actually physically moved into your trust. And from there, we'll explain to you how you can use it. So no parties in the trust need to even know they're forming a trust. So take example, if we don't even know we're forming the trust, when we sign something, we had no idea that we were the grantor of that trust. Right. We didn't have to be notified that we were signing a trust or signing into a trust. A trustee and a beneficiary don't even have to understand that they're the trustee or the beneficiary of the trust. As long as the law recognizes there's a trust and a trust exists, then we've created a trust.
Okay. Let's see. You pretty much read that without reading it, I think. All right. Panel 5.
So when we have an element of the trust, what is the intent? For example, we went to get a house. We wanted a mortgage on our home. That's an intent. What is the purpose of the trust? The purpose is we're forming a document between 2 parties. What are the parties? It's us and whoever we're forming the documents for. What is the special res? The special res is that document. So as long as we have the foundation or the formulation, a grantor, a trustee, and a beneficiary, we formed a trust. That's how simple it is.
Okay, just 3 parties. And once you master the authority or powers of these particular entities, then you can operate and move freely.
Exactly. It's just understanding who you are.
Yeah.
Because a grantor can also be a trustee, or a grantor can also be a beneficiary. It depends on you and what you decide, because you're the grantor. It's your signature. You're the one who has to step up and say who you are inside the trust. And automatically you're the grantor because you signed the document.
Right. And a lot of people get confused because of all these different, titles that wield specific powers, and they get confused that, a grantor can be, authorized representative, a registered agent, just all these different titles that they give us to clearly confuse us.
That's the whole thing. Once you figure it all out and you understand it, that's when they're in trouble. So that's what they don't want us to figure out.
Right. And that's what we do, is to figure it out.
We are going to figure out trust and how we can use the trust, and how we can use the trust for paying, for getting out of the public and using the private equity, because trust or equity, that's plain and simple. We have to start using the equity instead of the fiat currency. So in most cases, a trust can arise from conscious acts or a declaration of an individual group or an individual. So say example, you have a court case and you go to the court and the judge starts asking you a whole bunch of questions. Guess what? He just created the trust because it arose from your answers. You answered him in a certain way. So a lot of people are making a super lot of mistakes when they're walking into court saying, I'm the authorized agent. You don't have any proof of that. So you just brought private into public, and the judge is going to kick you out, completely kick you out. You cannot mix private and public together, because the court cannot work in private. The only time a court can work in private is in chambers in camera. They cannot stand out in the public sector and talk about trust, talk about anything. So this is where a lot of mistakes are being made in court cases, or people walking in saying, this is not my birth certificate, prove it's mine, or this is not my signature. Well, you signed the document, it is your signature. You did grant your signature on that document, but it's considered an unauthorized signature because you have no authority to that signature. You're only signing for the birth certificate, which is the estate. And you really don't have authority to do that because you've never created it. So we have different elements that are applied, and they use different names: a founder or a settler or a creator or a donor. These all basically, a founder could be the court. The court founded the trust, or you could be the founder of the trust because you founded your own trust. A settler, you could be the settler because you're settling an agreement, or you could be the creator. You created the trust, or the judge is the creator because you didn't step forward and create your own trust. A donor, you're the donor because you donated your signature.
That makes sense. Okay, panel number 7.
So this is just explaining a little bit about what founders are and what the court is doing. A founder in a trust is where the trust is by will. Okay, a will. I have the will to come here today to speak on Floyd's show to tell you what it is. Everything is a will. And we have a tester or testrix, which are words that describe it. A tester is a man, and a testrix is a woman. Yeah, is a woman. Sorry, sometimes my English is not so wonderful because I speak French all the time.
I get tongue-tied as well.
So we do have a founder. So we do know on birth certificates we're found liens. So we're a founder.
Right, lost and found.
Yeah, exactly. And the founder can be the trustee, which we are. We're the trustee because we don't know it. And when trusts arise, it's a conscious act or a declaration of the the declaration of a founder. It's called an express trust. So courts put us into express trust on a daily basis. Traffic tickets puts us in an express trust. Signing a check is an express trust. Signing any document is an expressed trust, because we don't have any idea that we're doing it.
Okay. Obviously, we don't have any questions from the peanut gallery, so we're going to move on to panel number 8. And listen, guys, I believe these terms are Latin, correct? Testator and testatrix.
Yes, they are. Everything is in Latin, you guys.
And
All their, it could be in French or in Latin.
right.
That's the 2 languages they basically use. Some are in Greek, as believe it or not. There's some words that are actually in Greek.
Right. And the reason they still use this terminology is so you have to hire somebody who's more mentally competent than you, who went to school to learn these Latin terms, which most of them don't even know anyway. And they're going to go look up in Black's Law Dictionary because they have one. They know where to go look. So yeah, that's why they still use these Latin terms as I work on my writ of habeas corpus today, which is Latin. All right, panel number 8.
So here I'm just explaining to you what these terminologies mean. And what is a testator? It refers to a person who has died and left a will. Okay, so that's your birth certificate. It's considered you died, and the birth certificate is your will, as your estate. So you need to create the will for it. The testatrix is just another name for a woman. So we have to realize how estates work and how estate law is, and how a woman is actually under their father until they get married, then they move under their husband until their husband or them divorce, and then their father is dead, then they become their own testatrix for the estate. As long as there's somebody to take over for the woman loses, her, power. It's just the way it is. It was set up with Adam and Eve. And that's how the Bible set it up. When God was the grantor of the trust, and Adam was the beneficiary of the trust. And when Adam married Eve, he became the grantor of the trust, which he took in Eve as his to protect her. So he's the trust protector. So it all deals with trust protectors and understanding how trusts form. And that means going all the way back to the very beginning, when we have to realize that everything was always formed under a trust.
Okay.
And then you see what a founder is.
Right.
A founder also refers to a donor or settler. So that's the person who's setting up the trust. So it depends on how they want to identify themselves. There is really no rhyme or reason for it. Usually you're an executor, which you're setting up your own trust, or you're the grantor because you signed it, or you could be the donor's settler, whatever you want to call yourself. And then the express trust is an international trust. And it's usually created because we didn't create one. And it can either be public or private. So the courts always set up an express trust to trap you into being the trustee of the trust. And because when the court sets it up, they're actually the real trustees of the trust, but they don't want to be the trustees because then they're liable. So they try to push the liability onto you by asking you certain questions. And once you answer the certain questions, oh, now they're the beneficiary. And now you're the liability, you're the trustee. So you have to turn it around on them. And there is pretty easy ways to do that.
Yeah, they do a good job of that. They're very skilled at what they do. Get us to acquiesce. Okay, panel number 9. Oh, hang on. Let me go back. A lot of people describe these different. Hang on one second. What do you need? Just a piece of paper?
Just call Scooter.
Pardon me?
Call Scooter.
Call Scooter?
You get checked.
Yeah, maybe for Christmas, I'll call Scooter. How I like to look at this as an analogy, because basically what you're doing is putting the trust hat on, but you can put as many hat bands or titles as you want. You can put one, you can put four, you can put, you can just keep stacking them up, but you're always going to have that trust on. And that's who you're operating for, is for that hat. You're just dressing it up in a different manner, but it's basically all the same fundamentally. And panel 9.
Okay, so when we have no conscious act or declaration, which creates a trust, and we know the trust exists, guess what? The rules of law give the judge the right to create your trust because you didn't step forward. You are considered incompetent or an infant or not a majority because you are not old enough to understand what you're doing. But usually at 21, you are supposed to step forward and recover your trust. Some laws or some states, it depends on the laws of the state or the laws of the country, most say by 25, you're supposed to have your trust. So it's always up to you to do it. If you don't do it, somebody's going to do it for you. So this is where it pushes you into becoming a trustee, because you didn't sit and define your trust, or you didn't define the situation, or you didn't represent the property owned by them under their control. So as you're in court, you are under their control, but the property is you, and you didn't define your own property. So this is where they catch you in court, and it's a statutory trust or a judge-made trust. And this is where all court cases lead.
Okay, did you kids get that? Because what she just said is probably, I don't know what the other panels are going to talk about, but I would say that was probably the greatest panel of import that you definitely want to chase, because most of you people are, like myself, have some pending or adjudicated court case that you are trying to win, overcome, settle, or discharge, whatever that looks like in your eyes. Okay, we're going to panel 10.
Okay, so what happens in court? You walk into a court with no trust. You have no conscious act or even any knowledge that you need a trust. So when you do that, the judge looks at you as an incompetent individual, so he knows that he can create the trust for you. He is your executor. So he literally takes it upon himself to create your trust. And the judge has the intent, the purpose, the parties, and the specific reb that he can prove just by the questions he's asking, which that gives him the right to claim the trust as the executor. So we don't want that to happen. After the judge has a stand and he can make the claim as a beneficiary, because he literally has made a standing. He literally is the executor of your trust because he created it, because you didn't create it. And now what he's doing is he's assigning himself as a beneficiary of the trust, and he's assigning you the liability of the trust as a trustee. So you're now a trustee, and you didn't make a payment or a disbursement. That's all they care about in court, proving that you have made your payment or your disbursement. And this creates a prima facie case against the trustee, which is a burden of proof that's put onto you. And courts, the court is equity, and it assumes that the trustee is guilty. So the court works in equity, but equity, they're supposed to work in private, but no, they're pushing this in the public because they've created the trust, but you don't know about it. So automatically you're presumed guilty before even anything is ever started, because you have no proof that you made a payment or you tried to do any type of disbursement on this court case.
Okay, so we're going to say it's a theory because nobody actually has proof of success using this methodology that we're currently discussing. So in theory, one would have their trust established with their EIN, take their certificate or declaration of trust, which is a revocable private trust that you previously established, and go into court and present that to the court to settle the matter. What does that mean?
Basically, what you're supposed to do is you're supposed to take that court case, which is your offer.
Right.
You're supposed to create your trust from the offer. You're supposed to move the offer into the trust and then present it to the judge. And I will go through the steps of how to do that come a little bit later on.
Okay. So we're going to go over that because I know I'm going to get a gazillion freaking questions just on that. Yeah. And I don't have, God bless you guys. I appreciate each and every viewer that I have. Everybody who leaves a comment, emails me, gets on Telegram, whatever. There's just one of me. And to produce these videos, as you can tell, takes time. And again, everybody who's watching this video, please thank Ann, leave a comment below thanking her for her time and effort and energy, putting all of this together for you guys with, out of the goodness of her heart. Yeah, thank you again. And I really appreciate you doing this. This is just freaking awesome. So I know you guys are going to, beat me up on that issue. So that's going to be covered here pretty soon. As I told you guys, I'm doing this with you. This is the first time I've ever read this. First time I'm being walked through this. So we're doing it together. I do have a pending court case. It's, it's already been adjudicated, appealed, mandate issued, which made it a final conviction, taken all the way to United States Supreme Court. However, I'm going back in on a writ of habeas corpus. But what I'm doing this time, so you guys understand, and I always try to keep it real and give you guys the transparency of myself, of exactly what I'm doing, my adventures, my pitfalls, misadventures, because that's what this video is all about. And that's what I try to effectuate with all my videos using their stuff. I mean, right. Yeah. I have to, let me stop share. Yeah. I mean, right here, this is a memorandum of law to 2 grounds of errors that I did in my original writ of habeas corpus that did get remanded back for an evidentiary hearing, but my trial court wouldn't do it. So I've walked the walk. I even published on Telegram today that the court, other plaintiffs or petitioners or applicants or whatever title that they have, as well as the Harris County District Attorney's Office, actually cites one of my cases in the legal vehicles that they're doing. So, it's real surreal to see that, but, I was throwing some heavy shit at them. So anyway, my point being, and I'll digress here, is that I'm throwing anything and everything I can at them to make it go away, whatever that looks like, whether it's discharge.
Well, hopefully by the end of this video, you're going to see a different light.
Okay.
A new light is going to come on that will teach you how to take that court case and bring it into your trust, and then take it out of the public and make them have a meeting in the private, in camera, that you can present your evidence that the trust exists. Okay. So basically, you're going to flip their trust around on them. Okay. And you're going to take yourself out of the liability and turn it around on them and hand them back their hot potato, and they'll have liability.
Okay. So basically what you're doing is they're working on presumptions of law, presuming you're the surety because you went in there as a belligerent and an imbecile because you hired somebody to represent you who has a license to practice law or practicing.
If you look at, wait a second, look at the word belligerent. Have you ever really looked up the word belligerent? It means a militant, somebody in the military,
Oh,
a combat of the state.
haven't gone that
So
deep.
I don't know if I would really want to go in saying I'm a belligerent. If I'm being honest with you, a lot of people use it,
Right.
but I do believe it's the wrong terminology.
Well, if yeah, possibly is. But if you're going into court and you're not trying to settle the matter in honor, good faith with clean hands, then you're an adversary and they see you as such. You're an imbecile because they ask you, are you going to represent yourself? Do you need counsel? Are you going to get counsel? Should we appoint you counsel? So yeah, I've been in all three positions. Okay, let's jump on to the next one. And panel number 11. There we go.
So what the court's doing is it's pulling you out of admiralty law. Everybody thinks courts work on admiralty law. They do in a certain aspect of it. But what they're doing is they're literally tricking you to get you out of the admiralty law into trust and equity law. And the court does that and has you under your control. Once the judge has asked you all the questions he wants to ask you and you've answered them, then that's when he's pulled you into the trust. So now he's taken you out of admiralty law and he's brought you into equity or trust law. And nobody's understanding that. It's a very slick sleight of the hands. So the only way you as a trustee can prove that you're innocent is if you can present a record of payment. That's what they've done to you because they've pulled you out of admiralty law into trust law or equity law. And now they're saying, where's your payment? And once you cannot prove you have a payment, the court only cares about that payment. That's all they care about. They don't care about anything else. Nothing about your case, nothing. Just where's my payment? I want my money because I'm the beneficiary. So this is their famous trick. So what they've done is they pulled you out of the debtor credit UCC, which is on the public side, and they brought you, boom, into the private side, which you have no idea what they just did. And they just created a negotiable instrument on your behalf. And now it's up to you to set off or discharge this instrument. And there's no way possible you can do that because everybody would run to UCC and discharge it off UCC. It doesn't work because it's not in the public side anymore. It's right now in the private side. It's under equity. This is where they get you. This is the trick they use against everybody.
Yeah. I don't know if so much a trick is just basic miseducation, programming, institutionalization.
Lawyers don't help because they're with the court, because if they get you guilty and they get the money, they're in on it. They're the beneficiaries also.
Yeah, it's a
So
band of brothers.
either is not really for you, even though he says he is. He gets paid by you, and then if he loses or whatever happens, he also gets paid by the court. So
All right, panel 10.
So what is really the remedy for all of this? The remedy comes in knowing who you are as the grantor and how the trust is created. So in a court case, when the judge creates the trust, you're automatically the grantor and you're automatically the trustee. no matter which way you handle it or how the judge looks at it, because he's created the trust, he's the beneficiary. So the key to handling this is to know who the signer is on the instrument. So you sign the instrument. The instrument is your court case or your arrest record or your release record or your document you sign to get into court or whatever you sign. Those are your instruments. So every instrument you're signing it as a grantor. So you're granting each instrument, and each instrument creates its own separate trust. So once you understand that, you can literally turn their offer around into a specific res. Okay, remember what I talked about? Res is anything,
Right.
and it has no value. So a specific res, if we turn it around, we can return it to the judge as it under trust. It's called a trust res or a trust deposit. So that's how we can clear up the cases.
So let's say you had a lengthy legal proceeding such as I did, which encompassed 11 months of going to court, signing reset forms, motions, agreements, all kind of stuff. So would you have to go back and get copies of all those reset forms that you signed? Because what you just stated is that every time you signed a reset form, you created another trust.
I would say yes, you would need to, because what you're going to do is you are going to create titles for those forms. And every title you're going to create, you're going to put it into the trust so that you can create the special deposit under the trust to wipe out the case and get it completely off the records.
Well, they're going to love me at the district clerk's office. Well,
See, they always said if we figured this out, they were going to be running for their lives. So this is what's going to happen. It's not that difficult. It's if you understand trust law and you start really just honestly digging into their dog Latin and tearing it apart with different dictionaries, different law books, and a different way that it's like explained, then it all starts to just like a light just starts to come on and you're like, oh God, it's that easy? No, it can't be that easy. But they wanted us to make it think it's super complicated, and it really is not.
You just have to go back and clean up your mess. And that's going to be the hardest part, is cleaning up your mess that you made.
Yeah, that's basically what it is. Get all the paperwork and create the mess or clean up the mess.
Oh yeah. I mean, if you saw, they're telling me that that's my complete file down there. I've been down there twice in the last 2 weeks to the district clerk's archival warehouse here in Harris County, Houston, Texas. And my file was, this tall, at least. And they're telling me that's my complete record. And I'm like, this is not my complete record, because I know what it looks like, because 90% of those documents that are in that stack like that, I create. So I know.
So if you created them, you can move them into your trust. You have the documentation.
Yeah.
So, I mean, you just have to literally go in and do the paperwork. So for example, let's say that you have an inanimate object, such as a cup, and this cup really doesn't have value, but how can you move a cup into your trust? You literally have to create on a piece of paper a description of what it is. And then you go to a notary and you have it notarized, because that authenticates it. And then from there, you can file it in the public. And once the public understands it, you literally can take that piece of paper and create a UCC1 and a UCC3 and literally move it into your trust or give it back to them, assign somebody else to it. It's It's that simple. It's just understanding how to move titles. The whole key is your title and how you're going to move these titles.
Right.
Yeah.
Okay. Yeah, see if you're there and you actually have the physical hard copy, because I actually have the wet. It's not, I don't, but I took a picture of it because my judge signed it in blue ink, but the wet ink signature of all the instruments in my case from the judge.
Do you know why you signed it in blue ink?
Because he's smarter than I am.
Because he's the executor of the estate. And executors, any executor notification or any trustee or beneficiary has to sign in blue ink. That is one key nobody understands.
I scanned it. Hang on. Let me show you guys, just so you guys know. So when you see it yourself, you'll know what you're looking like.
I don't think you're going to find judges signing anything in black ink. I think they sign everything in blue ink.
No, hang on. Let me switch these.
Blue ink is for the executor's office. So he has literally taken over the executor's office of your trust.
Right.
So he has to sign everything in blue.
Okay, I'm trying to switch. How do you, nope, that's not it. Anyway, I don't know if you guys can see that, but see, blue ink,
Yes. Uh-huh.
everything
And
else.
do you see how he makes you sign in black?
Yeah. Yeah. Well, he printed it. That's his printed signature.
Right.
Yeah.
But do you see where you have to sign it in black? They hand you a black pen when you go to court.
Oh,
You always need to take a blue pen with you when you go to court.
Yeah, they actually, this instrument, which is the judgment and sentence, they just want you to write thumbprint. You don't sign this.
Oh, okay.
You do a separate contract that your attorney, the assistant DA, the judge, there's 4 signatures on there.
Well, the executor will always sign in blue. The others will sign in a different color ink, mostly black, I think.
Yeah. That's actually it right there. I posted this in the Telegram. There's the 4 signatures. All 4 parties, which is myself, my defense counsel, the assistant district attorney, and the presiding judge. There's the contract.
You're going to have to learn how to sign your name here. You just don't sign your name to any document. You're going to have to learn how to sign your name.
This was May of 2002.
Yeah. My second part of this series is going to teach people how to sign their names.
Right. And we're going to get into that deeply.
That one's the most important.
Right. And especially the color of the ink you use. So yeah.
And size of the paper and the verbiage on the paper and understanding road of passages and different things. It's all so tied together.
Right. And let me throw this in the video, because this is actually a communique between, like a inter-office communique, is what we would call them. And this is from the Harris County District Clerks. And this is from Peter Zama to Deborah Selden. And this is from April 12th, 2010. And this is while I was in prison and litigating after I'd already been there for almost 8 years. Deborah, apparently the file was, quote, in hiding, unquote, and they just brought it up today. It takes up 2 boxes and Liz made copies of the judgment indictment. Do you need more from those files. So basically they were hiding my stuff. So that's how they like to play. So please beware when we go through this process that you're going to run into these hurdles, roadblocks, but you have to continue to overcome whatever that looks like for yourself. So, okay, let's get back into the panels. And that was panel 12. What is the remedy? And we're going to jump into lucky 13.
So here we have to understand that any offer that comes in the mail can be turned into a specific res and returned to the sender with a special deposit under the trust. So what do you get in the mail on a daily basis? You get offers. Offer to pay your electric bill, offer to pay your water bill, offer to pay your phone bill, offer to pay your cell phone bill, offer to pay your cable bill, offer to pay your internet bill. These are all called offers, okay? Judgments also come as offers in the mail. So if you have a court case, they'll send you an offer. So we're going to take these offers and we're going to flip them around and we're going to change the titles of them and we're going to put them into our trust that we create, and we assign the grantors, the trustees, and the beneficiaries. Because we're the grantor, we can assign the trustee and the beneficiary. So depending on what you want to do, you will either be the beneficiary or you will be the trustee. That's simple. You get to be one or the other because you're the grantor. And once we put these into our trust, it's called a trust deposit. So then if we look at the definition in the law dictionary, not Black's Law, a trust deposit is for the purpose of the depositor to make a payment for an obligation or a debt or some other purpose. So we move this into our trust. We created a trust deposit. Now we can take what's in our trust because it has no value. Remember, there is no value as a res or a trust deposit, and we can send it back to them. And we just made our payment.
Right.
And the grantor has the right to do anything he wants to do or she wants to do as long as it's lawful. So that gives us a lot of leeway in trust. If we decide to move it into our trust as a trust deposit, and we want to liquidate that to take that trust deposit to pay off the debt, or what we can do is we can take the trust deposit and we can reassign it back to them as the trustee. And then they're liable to pay it. And no court in the world wants that to come back to them. They want it to stay with you. So we have to flip things around. We have to think of mirrors, and it's like smoke and mirrors. So we have to use the magic tricks that they use against them.
And it is magic. Don't for a minute think it's not. That's why they wear the black robes.
I'm surprised they don't have the pointed cone on their head too, with the little stars on it.
Right. Yeah. Yeah. Whip out their Mickey Mouse Fantasia robe.
Yeah.
All right. Panel 14.
Okay. So here's what res means. Okay. It's Latin. So like I said earlier, it's just going to depend. Some is Latin, some is Greek, some is French. So it's just an object or a subject matter or a status against which legal proceedings have been instituted. So it's just a thing that they've created a legal proceeding over. So then it goes down and it explains, you know, for example, it's a suit involving a captured ship. Okay, let's go back. They want to try to confuse us with admiralty law. So let's not say captured ship. Let's say you're captured because they got you in their custody. Okay, so it's a seized person, or what they're saying here, vessel. And it's a res. And proceedings of the nature are said to be in a rem. Res, however, does not always refer to tangible personal property. It can be also a material, a matrimonial action. For example, a res is a marital status of the parties. So if you're married and you have a marriage certificate, the marriage certificate is considered a res, and that can go into your trust. A court case is a res or an object because they captured you, like on the sea or whatever they do or whatever they want to say. You can throw that into the trust. So that's what it's saying. What is a res? It doesn't always mean that it's tangible, liquid property or money. It means that it's an object or a thing. A thing can be anything. A thing can be a piece of wood. A thing can be a shoe. It can be anything you want it to be.
Absolutely. And a lot of people get lost in the whole marriage license thing, but basically you're conjoining your two corporations, and that's why you have to go back to them to dissolve it and divvy up the assets.
So in court cases, how do we even prove a trust exists? That's the thing. Because if you go up and you come into the court and you say to the court, I'm the exec, or I'm the authorized agent, I'm here to settle the trust. What is the judge going to say to you? He's going to look at you right away and he's going to look down at his papers and he's going to say, I don't see a trust. Why doesn't he see a trust? Because you haven't given it to him. You can't just come in and say, I'm going to settle the trust, or I'm going to settle the paperwork, because you haven't given it to him. You haven't given him your intent. So that statement alone leaves you so wide open. Now you can form the trust. And there's only three parties, like I've been saying: the grantor, the trustee, and the beneficiary. And you, like I've told you before, you're the grantor because you signed everything. And since the grantor and your signature is on the papers, now all you need to do is define the beneficiary and the trustee. The specific rev is the actual offer itself, or the court case number that you're going to turn into a trust res, the object of the trust or the thing of the trust.
Okay. And panel 16, sorry.
So when you start to do this, you're going to have to understand moving title platforms and how to turn offers into trust res. It sounds more complicated than it really is. So if there's not a title, you're going to need to create the title first. So say your court case has a title because it's your offer. But if you don't have a trust or a title as the grantor, maybe you have to create your trust first. So it just is going to depend on where you are in the situation is what you're going to do. And once you create the title of who you are, and that could be the beneficiary, then you're going to merge that title with your trust.
Right.
So moving, excuse me. So moving titles is necessary to terminate your case. So what you're going to do is you are going to compel the trustee to do their duties. So if you've created your trust, you've moved the offer into the trust, you can go into the court and you can present the trust. And then you can compel the trustee, which is the judge, to fulfill his duties and terminate the case or pay off the case or do whatever needs to be done.
Right.
Or you can literally come in as the trustee, and then it goes into a different realm where you cannot do this in public. You're going to have to do it in chambers, in camera, so you can produce your evidence. So it's all going to be done in a different, area, because once in public and you come in and you're waving all these paperwork and you're trying to throw all this paperwork into the court saying, here's my trust and blah, blah, blah. The judge is probably going to say to you, I think you need a psychological evaluation. So basically those little simple words are actually telling you to shut up and you're in the wrong jurisdiction. You got to change the jurisdiction from public to private. So now there's another procedure. You're going to do that, which is all in this document. So we'll get into that in a second.
Okay. And there are 41 panels in this particular presentation. So we've got a little over halfway to go.
Okay, basically, this is just explaining what your rights are as the grantor, and it's showing you the difference between the two trusts. What is the public side, what is the private side? People can go over this, if they want later on. And it's basically just explaining different types of trust, what trust laws are, what the live birth record is compared to the birth certificate. Okay, so the birth certificate is a certified certificate under seal of the state. Correct. And a live birth record is actually a record at the hospital where you were born, that they literally write down all the definitions, or actually it's like a document that literally spells out everything. So this is basically just a document explaining the difference of estate titles and trade names and things like this. So we can use both of these documents to create our trust. It just is going to see how we're going to use it and what is the best benefit for us. If we want to just recover our estate, which is our birth certificate, which is the certified copy of our estate that was mailed to us, and that was the first document we received as a baby, they sent us our estate. And at 21, we were supposed to recover that estate and become the executor of that estate, but nobody knew it.
Wow, this is phenomenal. I can't believe you put this together and are just putting it out there.
I've been studying this for several months. I've known the solution. I've known the answer.
Right.
I just, I've been trying to explain this to people, but it's like, you can talk to somebody, but unless they see it in writing, or they claim, I need proof. Okay, so I started working with some close people who are in the situation you're in. One person I'm working with has a child custody case, plus now, because he filed letters of intent against the sheriff department, now the sheriff department has him in a court case, for, what is it, disruptive service? No, I don't remember what he told me. Anyhow, it has to do with, being a public nuisance or something like this, because his neighbor ran something into his car.
Interfering with the duties of a peace officer or disorder, something of that manner.
Yeah. Well, their attorney just keeps, like his affidavit process, the attorney just keeps, sending letters. Right. Instead of sending the affidavits back. Oh, this doesn't apply to us. That's their response to his affidavits. Well, once they reject 3 affidavits, it's theirs. I mean, they know the affidavit law. So this is what is really funny when I'm working with certain people and seeing the responses they're getting back from lawyers saying, oh, you can't file this paper with us. Well, we just did. And we need an affidavit, a sworn affidavit that's notarized, giving us the reasons, laid out and disputing all the charges in order for us to not be able to do it. Well, they don't give it to us. So this is why they're coming after people in other ways, because they can't give it to us, but they want to stop us and deter us from, seeking what's, justice.
Yep. All right. Moving on to panel 18.
So your true remedy is always, always, always going to be in trust and equity. That's where it's been from the very beginning. It's always trust and always equity. And in trust, you are the lender of the assets that are held in a special deposit. Why are you the lender? Because your energy created the assets. Your signature created the assets. So if you never step forward and express the trust, you automatically become a debtor under UCC laws of the credit debtor relationships. So if you don't stand up and take responsibility for who you are, you're automatically going to stay in the credit debtor relationship, and you're automatically going to turn to UCC laws for remedies, which they don't work. They're out there to use against you, but you can use them in your favor. So literally nobody is expressing their trust interest in a court case. And if you don't express that trust interest, they're getting you under a bond. So here we go again. Everything turns in a full circle, a bond. A bond is your word. A bond is you. They are bonded. They're bonded for their word. Everything we talk about is a bond of trust, a bond, a trust, equity. So it all is in a full circle of where we're standing. And when you start digging into this, you're going to start to see the real relationship between bonds and trust. It's amazing how they just so entangled together of this whole situation. So the bond is actually with the trust. So what they do is they're creating this bond, and it's putting into the trust that they create, that they control, because they're the executors. And you don't have any say so over this unless you are the executor, unless you stand up and say, no, I am not an infant. I am not a child that needs the state to take care of me. I am a full-grown person that understands who I am, and I am taking responsibility of myself. And that's all it basically is you just need to stand up and say, okay, it's done. I know who I am now. I've learned my lesson. Thank you for being my guardian for X number of years, but I don't need your service any longer. So the bond is a trust, and it is also part of the trust relationship. You see how they all just easily just go together in a nice little glove?
Yes, absolutely. And this ties in the UCC, or what everybody calls the secure party process, kind of brings it full circle with some authority that you can easily wrap your head around how it applies. Because, most people are doing the redemption secure party process, which to this day, I have not seen it being effective for anything other than, wasting your time, energy, and money.
You're exactly correct. It is never going to be effective because they're still working in the public. Yeah. They're still working under debtor credit. Even becoming a secure party creditor is not going to help you. The only thing that is really going to help you is to take their paperwork, their UCC, whatever they're calling it, universal codes, filing their universal codes, going to the private with the IRS. Some of the IRS forms are private forms. Filing private forms with the IRS and moving that into the trust. Then you can rectify the problem and you can receive your remedy.
Right, exactly. So I hope that answered a lot of questions that people have in the back of their mind, especially when you see the UCC creditor-debtor relationship. I know that's the first thing that's going to pop in everybody's mind. Secure party creditor process. All right, panel 19.
So everything you're doing on a daily basis is a trust. So we all have interpreted this in the wrong way. Everybody has interpreted it in the wrong way. I saw it in a different way. I thought, oh, we just have to be an executor or, something else. But then when I started really digging into it and I started to understand how all this tied together and figured out courts and everyone else are putting us in a debtor credit relationship or status under UCC. So I started studying all the UCC laws and I saw where it happened. And then I'm like, crap, that's all anybody cares about is the UCC laws. Debtor creditor, I'm going to be the secure party creditor. You guys are looking in the wrong place. You need to start looking in trust laws, not in UCC. I'm going to be honest with you. UCC is going to get you nowhere. So in UCC, what is everybody telling you to do? Return it, sign it, accepted for value, or return for value. Guys, you don't even want to do that. That just puts you right back in the debt creditor relationship. And because you signed it and you put that on it, you're now a grantor of a new trust. And now you gave them your signature, which is an unauthorized signature or an unqualified signature. So because you're using the UCC codes, you can go under UCC 3 dash, I think it's 115, and read what it says. And what it's telling you is you don't have the authority to sign that. So you're automatically a debtor. And you gave us the right to add anything we want to the back of your signature and turn it into a negotiable item. Because what you're giving me back is a non-negotiable item. And I need a negotiable item. So because you signed it, you just gave me the authority to turn it into one. So now I'm going to get the benefits from it.
Right.
See, that's what people are not understanding about all this UCC, secured party creditors, and how this all works. And this is where they're getting in so much trouble. So in all trust, we have to have a thing in the trust. And what I keep talking about, things, res, papers, documents, okay?
Right.
And we are never, ever, ever going to call them accepted for value. This is the worst thing you guys could ever do, is write on there accepted for value. In court, court cases, trusts are the basic primer for statutory trust. So that's what they've created, a statutory trust. Wait till you guys figure out what statutory trusts are. I think that's on my next panel, explaining what that is.
Okay.
But I know I explained it.
Next video.
Yeah.
Yeah. What was that UCC code you just threw out there? For
It's UCC code 3115, 3-115.
115.
Yeah. And then that coincides with 3-402. And if you look at 3115, it goes back up to 104. So you have to literally see where in the codes they're giving you information, and then the information puts you up to another UC code. So you have to read the two codes together in order to understand it. And a lot of times they'll write the codes backwards so that it makes it more confusing for you to understand how the codes are working.
Okay. I'm actually reading section 3-115. Incomplete instrument means a signed writing, whether or not issued by the signer, the contents of which show at the time of signing that it is incomplete, but the signer intended it to be completed by the addition of words or numbers.
Right. So what you did is when you signed your name, you didn't identify who you are. that is considered an incomplete signature.
Correct.
And then that opens up the door wide open for them to come behind your signature and attach anything they want behind it, which could be a document, it could be numbers, it could be filings, it could be whatever they want to attach to your signature, because you just signed it and you didn't close it and you didn't do what needs to be done to the signature. Everybody just signs their name.
Right.
Okay. But if you put a period behind your name, guess what? You just closed your signature. And they can't attach anything to the end of it because that's the end of it, period. My signature, period.
Right.
You know, so there is just so many tricks out there that if you just understood the small little tricks, you could get out of all of this.
And the easiest example that I can give everybody is if you get a check, and especially a paycheck, and you flip it over to the back and you endorse it, sign your name like they want you to do, and then it says, do not write below this space, because that's where they go in and put their stuff on it and start hypothecating it. That's the easiest example for everybody to understand. All right, we're going to move on to panel 20, which makes us almost halfway there.
Okay, so here, you guys, we'll read you what a Sagittary trust is. Okay, there's two meanings of it. So you should consider a Sagittary trust as a black trust. So we're looking at black and white. We want to work in the white, but the courts work in black. That's why they create the Sagittary trust. The trust is a type of a trust that a court, bank, loan institution, or utility company creates against you because you have never stepped up to take the executor's office of any trust or your own trust. Sagittary trust, okay, in red, means a trust fund established by state law to receive funds allocated to the state abandonment account fund. Guess what? Every time you go to court, there's a fund, and that's what they use against you. And that's where these attorneys have to deposit their bonds into it. So there's money in those funds already. And if they win the case and you're convicted or you have to pay, all that money goes into that account. So what they're after. So this is where it's, you know, really messed up. So a state can give us a Sagittary trust authority to allow one or more of the 3 settlement funds, but it's not required. So there is different settlement funds in court cases. I haven't dug into all the different settlement funds, but I do know that, you know, when you're in jail, they take out bonds from you and they tap into the bonds, and everything is done through bonds. This is why it was so interesting to start Bonds for the Win, because it just taps into trust, bonds, and how they are working in the system.
Okay. Panel 21, we are now over halfway there.
Okay, so we are literally creating negative instruments. So as long as we continue to work in accepted for value or return for value, we're literally creating a lien, which is under the UCC negotiable instruments. Under the law, everything is a negotiable instrument, which is in the debtor-creditor relationship, and you are just creating the debt. The money we're using in the system today is debt, and this benefits them because it's functioning as credit. So remember, checks and balances, everything in debit has to be in credit. It has to balance completely. Your accounts need to balance. So you're creating the debt. Guess what? They get to create the credit. So the books balance. So the more debt you create, the more credit they get to create. And then they have access to the credit. We don't, but we can if we use it correctly. So credit is the only thing we should be using as money. We shouldn't be using the debt instruments to create the debt. We should just be tapping into the credit to wipe out the debt. And if we start using our credit, it starts lowering the debt, and it also starts lowering the credit. So sooner or later, it's going to zero itself out on both sides.
Right. Okay. Panel 22.
So each time we put our unqualified signature on a piece of paper, we're creating a lien. So if we signed a promissory note, that's what a mortgage is. It's a promissory note. We signed the promissory note. Okay, we just created a lien. So we're not expressing our signature as a trust. Therefore, we're creating liens. We're just making a bigger debt to pay another debt. They have this system which is so rigged that we have double debt upon debt. This is how bad they've rigged it. Right now, it's almost like double debts upon debts. Every time we sign something, it puts the debt upon debt upon debt. So in all of reality, if they mined the whole entire world for gold, silver, precious metals, or whatever, there would not be enough tangible assets to pay off the world debt. It's because it's an illusion they created. This is what's so sad about it. So we're just creating more money for them to utilize. The more debt we create, the more credit they have, the more they can use it. So all the money we pay out each month has never ever touched the set off on the private side, because we're paying with debt instruments. What does it say? You cannot pay a debt with a debt. So promissory notes are a debt instrument. So we're paying a debt with the debt. So are we really paying the debt? No, we're not. So each time we sign a piece of paper, we are just adding to the public debt. That's how it's working.
And that goes for a stock, a bond, promissory note, draft, check, coupon,
Credit
voucher.
card receipt.
Yes. Yeah. Actually, a bill of exchange.
Mhm.
We are changing the name of your receipt to a bill of exchange, because that's exactly what it is. And if you look up bill of exchange, that is a security instrument. Absolutely. All right. Panel 23.
So don't know if you guys realize this. Under a trust, you'll never have to give a value for anything at all. So anything you move into that trust, you're not going to give it a value, because there is no value, because there is no money. It's just a piece of paper. It's like an inanimate object. So whatever you move into the trust is considered a thing. It's considered a res or a thing. This creates the principle of the trust, which is the property of the trust. So everything you move into that trust, you're creating principle and you're creating property. A court case or an electric bill, credit card bill, home loan, or any other type of bill you receive in the mail is considered a res or a thing. And all of that can be moved into your trust. Every single thing you receive in the mail, every single thing you sign, every single thing you do can be moved into the trust. So if you have a checking account, before they used to mail your checks back to you every single month. I don't think they do that anymore, but if you want, I think you can get them mailed back to you. So imagine every single check you wrote, you signed it. Guess what? You can create a res for that check and move all that into your account. That gives you, believe it or not, property, and it also gives you the principal inside your trust. So you're just building up your trust. Every piece of paper you move into it, you just build up your equity, your principal inside that trust. It's pretty amazing, isn't it?
Are you there?
Yeah, I'm here.
Okay, hang on 1 second. I'm going to pause the video for a second, Ann. Hang on.
Okay.
All right, we're back. I had a phone call regarding my stolen phone, so that's what I had to deal with. So we're going to share the screen, get back on track. All right. And I believe you covered this, correct?
Correct.
Okay, that was panel 23, moving on to 24. And here we go.
So you're going to need to use your trust to pay your bills, and using the credit in your trust to offset your public debt. It's pretty simple. We just are going to move everything, pieces of paper, into the trust, and then the trust is going to offset the public debt because you're going to use the trust to pay the bills. So your trust operates solely in equity, and that's where the power comes in. It comes into the trust. So equity takes you out of the public debt system and puts you in the private credit system, where the trusts are used to pay off the public debt with the private credit. So all things received in the mail will be moved into your trust. Like I said, you're writing a check and you sign the check, that is creating public debt. So if you can get a copy of your checks every single month mailed back to you, and you just move all those into your debt, now you've created equity, and you've created property, and you've created money inside of your trust just by moving those canceled checks into your trust, because they're promissory notes. So all things you receive in the mail, you're going to move everything into the trust. And what you're going to need to do is you're going to have to understand title platforms. So people might need to do a little bit of research on title platforms and moving titles in trust. It's not that difficult. You are literally going to use their debt credit system of a UCC1 and a UCC3 to move titles around. You have to. It's the easiest and fastest way to do it. So from there, you're going to create the res, which is the credit. And the res is what you just moved into your trust. It's the title. It's the electric bill. It's the mortgage bill. It's the tax bill. It's whatever you moved into it. You're going to be able to create the res from it. So the credit is then going to be used to offset the debt and pay the debt on the public side. So through your trust is how you're going to offset the bill, using the res and the trust payment and the trust res.
Okay. Hope everybody understood that. Panel 25.
So what we're doing when we're moving titles into our trust, and we're functioning in commerce. This is how they function. They move every single title into a trust. They create their own equity, and they function in commerce. So as the grantor of the trust, we have the right to give specific orders that will convert the assets to money on the public side. This is all done through trust and trust laws. We can also issue orders to convert the res to assets that we can then take those assets and pay off the debt on the public side. Being the grantor of the trust, we also have the duty to do whatever the will of the grantor is. So whatever my will is, because I'm the grantor, remember it's free will. My will is, okay, I am going to take this, I'm going to put it in my trust, I'm going to create my res, I am going to turn it around and no longer be the trustee of this res, and I'm going to send it back to the company who sent it to me, and I'm going to name them as a trustee. So now they are liable for paying that off. I'm no longer liable. Or what I can do is I can turn it into cash, use the trust with a trust deposit, and send the trust deposit to them to pay off the debt using the private equity. So the benefit of a third party could be the beneficiary or even the grantor of the trust. So it's always in third parties. It's always the way they've always worked. So this is actually alienable or beneficiary's interest. So everybody's talking about unalienable rights. Okay, that's who we are. So it's beneficiary's interest. So this is what trusts are. It's the same thing. There's no need to change names, titles, or anything else. The only time you change a title or a name is when you move it into your trust.
Okay. Panel 26.
So what is our right to transfer? Beneficiary interest in the trust are freely alienable, or what it is a lien by the beneficiary unless there is a valid provision to the contrary in the trust instrument. So we're looking at trust instruments, and we design the trust. We're the ones who write the trust instrument. We're the ones who give the criteria of the trust, and we're the ones who have to define everything. So we define the beneficiary, we assign the beneficiary, we give the pledges, this is all from the law dictionary. It literally is coming right out of the law dictionary, what I have here. And it's definitely just explaining what the interests are, the transfers in trust for another. Also, if the interest is not conditional, everything we have to do, we have to lay it out on the line. It's not that difficult. I've already done a lot of examples. People can, take these examples and they're going to have to modify it. You guys cannot just copy and paste something that is an example of somebody else, because they all have to be personal, because the example is like a broad example, and maybe that broad example doesn't fit your personal profile. So you always have to modify everything that anybody does. And I do see that a lot, especially with when we're working with the bonds. Everybody just copies and pastes everything. This is where you guys are getting in trouble. You shouldn't do that. If you have questions, just ask. And people can help you modify your examples or modify your documents. And then you name your beneficiaries, you name your trustees, and you create your will, because your will is you. Whatever you will is what you create.
Exactly. And panel 27.
So the beneficiaries, guess what? They're the equitable owners of the trust or the estate. Their interest, which is their title, are property. Yeah, guess what? Beneficiary is property of your estate. So like if the court wants to be your beneficiary, you can make that court the property of your estate. That's how funny it is. And nobody understands that. And each therefore has power to transfer and convey his or her interest in the trust to the same extent that he or she could transfer her own property. So this is how the courts are doing it, you guys. They literally are putting their title as property inside the estate they created for you, or the trust they created for you, that they're the executors of. And now they are literally just moving their own interests around inside of the trust so that they can benefit from the trust.
Okay. Hey, look, there's the end. Panel 28.
So here it's just coming through and explaining to you what the transferee's rights are. A beneficiary can assign only such interest in the trust that he or she has. So in trust, you limit what interest a beneficiary can have in a trust. If you are the beneficiary, you don't have to limit anything. If you want to assign the court as the beneficiary, then you limit what you give them or what they can do. The transfer is not a transfer of the trust itself. So that's where a lot of people are getting mixed up. They're saying, well, the transfer is transferring the trust from us to them. No, it's not. A beneficiary cannot transfer a trust. They can only transfer interest, and the only interest they can transfer are the interests you gave them. So it's only the equitable interest that the beneficiary title has that they can touch. So whatever conditions or limitations in the lien that you put, that you created by your will, by the grantor, has to attach to the beneficiary, and it's the beneficiary's interest prior to the assignment, which applies against the assignee. So they have limited capabilities, but if you don't assign them and you're not the assignee assigning them, then, and they're the assignee assigning what they want to themselves because they're the executor and they created the trust, then that's where the problem is coming in.
Right. They are on the presumption that you've abandoned everything and are incompetent to handle your affairs. So they're going to do it for you and reap the benefits.
Well, you're still under their guardianship.
Yeah.
You're still a child. You're still considered
state
under 21 because you never stepped up. You never, identified yourself.
Yep. Okay. Panel 29.
Okay. So what does it mean that I just talked about? In court cases, it's a debtor-credit relationship. And they are claiming that they are the beneficiaries of the trust because you never declared the trust. We've spoken about that earlier today. This gives them equitable ownership of the trust estate because they created it. So they have the equitable ownership. Even though you're the grantor because you signed it, you didn't create it. They did. And remember earlier, I told you, if you do not create a trust or you do not have a trust when you walk into that courthouse, they're going to create one for you. That's just the way it goes.
Right.
The court's interest or title are the property of the trust. So it all belongs to them because you didn't limit what they own or what they have or what they can take. So it's their power to transfer or convey their interest in the trust. You gave it to them. You just signed it. Open signature, UCC 3-115. They can add whatever they want to the back of your signature. The court or the creditors can only assign an interest in the trust that they have the legal right to assign. So because they created it, they have all the legal rights in the world to do whatever they want. If you create it, they have a major limit to their legal rights.
Yep. Man, thank you again for doing this. This is just freaking awesome. Unbelievable. Yeah, this is just so well put together and well written and concise. And with you explaining it or narrating it is just, yeah, phenomenal. All right, panel 30.
Okay, so when you walk into a court, you're going to have to prove you have a trust. You need to take ownership of this trust that was created between you and the courts or the creditors. So a creditor creates the trust between you and him when he sends you that statement, that credit statement, how much credit is in your account every single month, that you rip it off, sign it, give him free realm to it, and send him a check on top of it. So right. You have to start limiting what powers you're giving these people. That's the whole thing. You have to know who you are. And it's not status, standing, blah, 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 blah. It's not changing your standing or your status to state national. Because if we look at all these wordings, they don't exist. It's something that somebody made up. And it's not even viable in a court. That's why all these people are getting thrown out of court, and all these people are getting thrown in jail, and all this stuff is not working for them, because it does state right in constitutions, if the state says it's the state of Arizona, you cannot say I am an Arizona state national. You can't do it. You cannot create your own titles. The only title you can create is the title you were given at birth, and that's your equitable title, and that's the title you are granted for, that you can sign for. You can't sign any other way. That's the end of the story. So once you can prove that there is a trust, you can transfer the titles into the trust, and this creates the res of the trust, just what we were talking about. Court case is an offer, court case is a res, court case has a title. Create the title, transfer it into the trust. With the res, you can now offset the debt to the courts or the creditors using the equity. Remember, no value, everything produces equity in a trust. Right. So you use the equity in the trust to offset the debt. Yep. So in a court case, you are just basically going to offset the court case with the equity inside the trust.
I hope everybody understood that. Well, it went a little deep, when you start talking equity and funding the trust and res, assets, liabilities, debts, credits, it starts, starts blowing by people's minds. It doesn't absorb and where they can think about it. And
yeah, it's all accounting. This whole thing, all of this is based on banking, guys. Every single thing that I'm talking about is banking. And it's just understanding accounting. And I'm sure in school, I know when I was working for the government, I literally had to take classes to keep up with all this stuff, because I was in charge of 17 people. And one of the classes I was forced to take was an accounting class. So this is kind of how you see what debits and credits are.
Right. And let me back up a little bit, because I didn't follow up on something you said in an earlier panel, like 2 or 3 panels ago, regarding copy and pasting templates or forms or instruments, documents, however you want to label it, that are published by other people, or you rip off Scribed or some other place, or it's stolen from some guru or whatever. That's probably one of the worst things you can do, is copy and paste a document and just put in your own proprietary information. And I'm guilty of it, and I'll stand up and be the first to do it, because you don't understand what you're doing, why you're doing it, and how you're doing it. You're just, you're going to the grocery store and you're buying a fish, as opposed to learning how to go catch your own fish. And that way, the next day you can go get a fish, but you don't have to get it from the grocery store. You can get as many fish as you want, because now you know how to fish. So when you're doing this and you set up a trust, and even though I do offer a very complex trust and ancillary documents for donations, I tell everybody, don't just take it and, go try to, operate with it. You need to understand every word of every page of every instrument in that trust, and what it's for and how you can use it. And I can help people with that as well. So I'm not pitching, I'm not selling or anything like that. I just wanted to make that clear, that copy and pasting other people's stuff for your use without your doing your own research and your own knowledge is probably one of the biggest disservices you can do trying to move forward with any of these processes. All right. And
I agree with you because I've read some of the documents that are out there on these different platforms just to get an idea of how they're formatted. That's the most important thing. Most of them are formatted incorrectly, especially if you want to deal with trust. Everything is always written on 8.5 by 11 sheets of paper. That is the worst thing because that is putting you into de factos. Everything should be written on legal documents. That's it. Everything is legal. Everything in trust, just like you saw him earlier, you saw Floyd earlier, show you a document that the judge signed in blue ink. Guess what? Everything in trust is written in blue ink. It cannot be written in black. And there's certain laws to trust and certain verbiage in trust that you can use. And there is certain things that, you know, need to be formatted into a trust, and you just need to understand it. If you take a base letter that somebody else has done, you can rewrite that letter to suit the circumstances you're in.
so do you suggest publishing your trust on 8.5 by 14 pieces of paper?
Mhm. Because you want to go into de jure. You want to get out of de facto. And everything that files in a court, they use 8.5 by 11 sheets of paper, which puts them in de facto. And if you start filing everything in court in 8.5 by 11, you're going to blow their minds because you are going into de jure and they can't handle it.
8.5 by 14.
I mean, 8.5 by 14.
Okay.
Excuse me. You're right. Yeah. Every legal document, you want to go into legal size documents. You want to get out of standard documents. Everything should be legal. And all your signatures should always be signed in blue ink. And anything that's coming from a trust, a grantor, a beneficiary, a trustee, or an executor of an estate, or an executor of the trust should always be in blue ink, written in blue ink. There is a certain format that you should be using that is not being followed right now. And putting on a trust from an executor, notice to, you know, what is that? Notice to plaintiff is notice to beneficiary. What is that one that they put on? Notice to something.
Notice to principal doctrine. Notice to principals, notice to agent, notice to agent, notice to principal, and that's
Yeah, you don't want to put that on a trust. You don't want to put that on your trust documents. And I see that all over the place. One person came up with it, they put it out, everybody copies it. See, that's the whole thing. You guys sort of need to start looking, you know, into some law books. And there is some really good trust books out there that explain it in, you know, super simple terms. Some of them are a bit more complicated, but once you understand it, it's pretty simple. It's all the same. Transfer, pay, transfer, pay. Transferring titles into the trust, using the trust to offset the titles or set off the debt. And that's the most function you're going to use in your trust is the transfer titles.
Yeah, I'm looking something up real quick. Okay, we'll go on to the next one. Panel 31, 10 more to go.
So the whole situation is once you take ownership of a specific trust res, which that means a document as your property. So basically you're going to take that core document, you're going to take that bill, you're going to take it away from them, you're going to bring it in as your property of your trust. And once you do that, it's possible that you can put it into a special deposit. The way it sits right now, you're in public, you have to use UCC, which you don't want to do, or accept for value, return for value. You don't want to treat it like that because it's never going to work. And like Floyd said, he's seen hundreds of these examples and nobody has received any remedy. You need to start recovering it. You need to start taking possession of it. So you now have a special deposit for the sole purpose of using it for the beneficiary. So if your court's the beneficiary, you have recovered his document that he wants to hold on to because he wants to make you liable. You flipped it around on him. You have now taken possession of that document. You have now put it in the trust that he created because you actually created it because you're the grantor. The court is making you believe that they created the trust. No, they really didn't. You actually created it because you're the grantor. So once you can flip it around and put that document into your trust, now you can use that document as your instrument to give it back to the court and flip it around on them and take the liability away from you and give it back to the court where it should be all along. So let's say that you're the beneficiary and the grantor of the trust. You can be both. Remember, you can be the beneficiary, you can be the grantor and the beneficiary. Or second, you can be the grantor or the trustee. You have to decide what you want to be. So that's the whole key. So the trustee who you have assigned now has the duty to pay the obligation. So guess what? You took the document away from him and you're now hiding it in your trust. You have now assigned your trust, beneficiaries and trustees. And guess what? You don't want to be the trustee. You don't want that obligation. So now you're going to give it back to them. So now you're going to use the judge. And in your trust account, the judge is going to be your trustee. So guess what? You're going to give the obligation right back to him. So all debtor credit relationships operate in the same way. Even if you have a mortgage, credit card, electric bill, or anything else, everything operates in the same way. Everything is under a trust. Everything they send you is a trust. How are you going to handle it? How are you going to deal with it? Put it in your trust, take possession of it, put it in your trust, sign them as a trustee, send it back to them, tell them to take care of it.
Yay. It sounds so easy, right? Okay, even a caveman can do it. Panel 32, here we go. Are you there?
Yep, I'm
Okay.
here.
Yeah, that's panel.
So how are we going to prove our trust? In order to prove the trust between the court or any other offer that comes in the mail, you're going to need to start to create the records. Okay, everything needs records. So what are the records we're going to create? It's our evidence. We have to create the evidence that is undisputable in court. Okay, so each state has their own evidence rules. So this is where you guys are going to have to do some research. You're going to have to go into the statutes and the rules for creating evidence, and each state is different. So once you understand the rules, then you're going to understand how you can create your evidence.
Right. Okay. Yeah, let me correct that typo.
Yeah, it says days instead of says. It says.
Right. All right.
Okay, so it's pretty easy to create evidence, guys. Guess what we need? A notary. Okay, so a notary is a self-office. Oh my gosh, let's get some tongue tied. They oh my gosh, I can't even say it. I'm going to want to say it in French. Authorize their signatures. Okay, And in court, it gets rid of the hearsay objection by getting a notary to sign everything. And on all the paperwork we're creating, we need to use the notary. So everything we do is going to have a notary on it. Everything we do is going to be on 8.5 by 14 sheets of paper. Everything we're going to do is going to be in blue ink and signed in blue. The notary part of the document is going to be in black. The notary part has to be in black. So you're going to have 2 colors on your document. So we need to prove that there is a trust, and a trust forms upon the
Hang on
present
one second.
by-
Hang on one second. Okay, go ahead.
Okay, so the trust forms when we can present the transfer of the trust property or the offset. So remember, a bill or a court case is an offer. Everything we get is an offer. We'll form the trust on each of these offers, so we can transfer these offers into our property, and we can recover them as our property. Each time we form a record or a transfer, we are creating the formation of a trust. We need 2 records, only 2 records, to prove we have a trust and that we've created the trust. I'm getting to the records.
Okay. Sorry, my roommate just told me he just got out of the emergency room. He got rear-ended and his vehicle's totaled.
Whoa.
Yeah. Yeah. And I got a phone call all at the same time. So hang on. All right, panel 34.
So guess what? There's 4 simple ways to create a trust. We have a declaration by word of conduct. So I'm going to use my words. I'm going to create my trust. Okay, I've got it. Now we have to transfer our offer. We're going to use UCC 3-200. Read what it says. It tells you exactly how to transfer it. We need an endorsement. Anything someone signs. How do we get their endorsement? We send them a certified or registered letter. And we send the documents to them certified or registered. They have to sign it. So there's their endorsement. We just got them to endorse our trust. Bingo, super simple. How did we deliver it? We have proof we delivered it. We delivered it by mail. We delivered it using our certified documents, okay? And the assignment, which is the name of UCC1. So I am going to claim it. Oh,
Okay, so
claim it, you won, and you literally turn it around and transfer it using UCC3.
okay, so even to
So
go ahead.
yeah. So now we have the appointment and we have the contract. So we're appointing them and we sent them the paperwork.
Okay, so and even I got like 4 people texting me right now. Sorry. So anyway, to strengthen the certified mail with return receipt of merchandise, which would be, if you actually look at the green card, that's what it's called, return receipt of merchandise. So the merchandise would be their signature acceptance. Make sure that when you do that process, that you put that the addressee is supposed to sign for it. So the USPS carrier doesn't do it for you, which I have seen being done. But you can also get a notary to do that. And I have the process for that as well, to do the notary presentment in lieu of you doing a certificate of mailing enclosure with whatever you're sending out. So that would probably be a whole nother video. And all you're doing is just adding another layer of protection and authenticity to what you're trying to do, and kind of take it out of your hands and putting it in the hands of a certified, licensed public official, i.e. the notary public, and allow them to handle it for you. So if there ever comes a time when you have to defend your position or your actions, you just go, hey, here's a public official. They're the ones who certified everything and they did it for me. So yeah, we can do that.
As long as you can prove endorsement and they sign for it, and as long as you can prove delivery, you have the 4 elements to create your trust.
There you go.
You just need that.
Okay.
You just have to prove it, and you have to have the paperwork, and you have to keep the paperwork. So when the card comes back, wow, I have my endorsement. I have my proof of delivery. That's it.
Well, okay. Yeah, that's something we'll get into later. All right, panel 35.
So we're creating our method of transfer, for which method we're going to use in the formation of our trust. So this is how it works. We have to create our method. We have to get the endorsement, the delivery, and we have to create our information. So the endorsement comes when we mail in our paperwork to the person by certified or registered mail. When we receive this certified mail or the green card back, we have the person's endorsement on it. Oops, there's a six at the end of it. Another error. The green card also is your proof of delivery. So this is the one, this is one of the methods we're using that we need to use to create our trust.
Panel 36.
So we've now created our method of transfer for the method of formation of the trust, which is done by endorsement. So this is under trust law. We have delivered the papers to the person who signed for them and assigned it under UCC 3. So once we deliver those papers to the person, they sign it. Now we can take that paperwork and we can create our UCC 3 with it. And that gives us the power of transfer. And I must first do a UCC 1 because I have to claim it. I can't create a transfer before I can claim anything. So I first have to claim something before I can transfer it. So the first step would be to create my UCC 1, claiming this document, claiming this court case. Okay. And once I can get that done, then I can use the UCC 3 to transfer ownership away from me back to them. And I now can do something with it, which means I can assign it to somebody else. Remember, we are the grantors that give us the right to assign beneficiaries and trustees to our trust. So do I want to assign my UCC 3 back to me as a trustee? Heck no. Do I want to continue to be a liability and a trustee? Heck no. I want to be the beneficiary. So now I'm going to assign them as the trustee, and I'm going to give the liability back to them by just 2 simple papers, UCC 1, UCC 3, creating a trust, intent, delivery, endorsement. Voila, I've got my trust. I've got all my paperwork. So now we can take all of this because it's ours and assign it to a trustee. So we just basically took ownership of the court case. Right now, the court case, the court owns it because it's against you. Take it, take the ownership, stand up and take it away from them. And then you can use it against them. So in the court case, even the bank or any other company, you can send the bill in the mail to them. Yeah. You can turn around and send it back to them and send them a bill. Because now you're not liable for it. Now they have a liability because you gave it to them, because you assigned them as their as your trustee.
Okay. Which kids, I'm going to do this process because I got a handful of those.
I'll help you.
Oh yeah, here we go. All right, panel 37.
Okay, so what happens now? We'll deal with the court cases now. Okay, I'm going to start dealing with court cases. I'll stop with the bills. We'll start going to court cases. In a court case, we have made a claim that we have a trust. And now we can prove we have a trust. Our green card, our notarized letters, our UCC1, our UCC3, our intent, what we wrote up, how we assigned our beneficiary. So we have our trust. We created it. So we no longer are working in the public, and we must switch to the administrative side of the private side. The court knows we have the papers with us. If we waive them in front of the court, they're not going to like this because they don't want anybody to know about this. This is hush, hush. We have to keep the secret, because if people know about this, every court case in the world is going to be discharged the same exact way. So remember, we have mailed them the trust documents. We mailed them to the court. They signed it. Okay. We told them they're the beneficiaries. We put the judge's name on our document. Who is the beneficiary of your trust? Judge so-and-so. Okay. So we already gave him his title. He's a beneficiary. He's no longer, he's a trustee, no longer a beneficiary. So now we can use the res, which is our court case, and give it back to the court under registered mail. We're going to resend it back to the court under registered mail. Isn't this fun, guys?
Yeah, absolutely. And when you do registered mail, go to a bigger post office and get you a firm mailing book. Or called a PS Form 3877. It's a book, and it's called a firm mailing book for accountable mail. And I actually should do a video on these to walk everybody through them, how you're supposed to complete them and how you keep records. And I actually have one for public transactions and one for private transactions. Absolutely.
Well, we're gonna do another video changing our mailing address. We're gonna do videos on signatures. We're gonna do videos on everything that we need to know and understand of how to move in the private.
Yeah.
And one of the first steps of doing everything is changing your mailing address, which is a simple procedure. It's just a letter from the executor's office.
Okay. Also,
Yeah.
I always forget the name. Per Q mailing.
I've never done that one.
Okay.
I don't think it's really that necessary.
Yeah, but you said you have one for 8 cents per mailing, which is.
Oh, yeah.
Yeah.
Okay. Yeah, I know that. Okay. I understand what you're talking about.
Right.
Yes. And how you're going to start using, instead of registered certified mail, and you're going to create your roads of passage underneath your address so that they cannot pass the line of passage, and you automatically create a certified document for every document you write. I have that too. I can teach you guys how to create your own certified documents
Right.
using the
All right.
postal codes. Not even the postal codes, but the postal stickers of the certified sticker.
Okay.
And that's one of the processes we're going to go through in all of this. It's pretty interesting. You guys are going to, when you see all this, you're just going to say, wow, why didn't I do that before? It was so simple. So now we have our trust. They have all their certified documents. We mailed everything back to them. Now we have to go into our state and understand how protective orders work, because we literally have got to put a protective order on those papers, because literally they cannot go in the public. They have to stay in the private. And the only way to get them in the private and get them into the court system is to get the protective order on those documents. And you're going to have to understand how to do that. And I can't tell you, because every state has different laws. So that's one thing you guys are going to have to look up, is your different state laws and how you get your documents under protective order. Because once you put the documents under protective order through the court system, you are now foreign to the United States jurisdiction. So now that you're foreign to everything that deals with courts, and you are considered to be a diplomatic relations. So that's what you did. You just changed everything around. You are now, because you have diplomatical papers, because of your trust, you're now under diplomatical relationships with the court. And that's where you want to be. You want to be higher than them. So now you have to establish that you have now you already have established that you have trade secrets or information, because you have protective orders on your confidential commercial paper. And that's what they're calling this now. Your trust is now considered confidential commercial paper. So it's the information, and now you can request, believe it or not, an in-camera hearing to present your documentations in camera, in chambers, to the judge only, because that's the only way, that's the only place you can present them.
And for kids out there who don't know what the term in camera means, that means the judge's office behind the circus that's going on outside in the public. Okay, moving on to panel 39.
So if the court refuses to grant you an in-camera hearing, they're not allowing us to bring our evidence to prove our case. And we're going to prove our case because we have a trust. So this is a violation of due process. So then here we go. If they don't grant us, then that means the court is corrupt and there's no longer due process. So basically, we're going to need to appeal the case. And if they again deny us a due process, guess what? We automatically win the case. That's law. That's the law, guys. They can't deny us of due process. And if they do, and we go after them and appeal it, and they still deny us, then we win. We win the case by default. So all we need to do is get this evidence into the court so that we can prove that we have a trust. And that means bringing in your UCC1, a certified copy of it, a certified copy of the UCC3 filing, the signed receipts that you mailed stuff to the courthouse, all your notarized documents, and your trust, what you assigned, your assignments of your trust, and how you move these into the trust. That's all you have to bring in. That proves you have a trust. That proves you're competent and you are of legal age and standing. No need to change statuses. You just did it yourself. So once the evidence is entered, we can now give the instructions. Here we are. We're in charge now. They're no longer in charge. We can now give the judge the instructions to set off and discharge the case, which brings the accounts to closure and a settlement. You can settle your own cases by just doing these few steps of creating your trust. And you can also demand, because there's bonds on all these cases, they have to bond everything when they go into court. So Floyd, you must have probably 30 or 40 bonds out there and all this mess that you're involved in. You can actually demand the payment of the bonds in this hearings. You can demand them to send the payments to you. Yeah.
I would say more like 300, and that would probably,
However many, and I know every day you spend in incarceration is an astronomically huge bond that you can recover.
oh yeah. I mean, I can't tell you how many different case numbers, appeal numbers, writ numbers. Oh,
Everyone has a bond. The
Oh.
judge has to bond it, the attorneys have to bond it, and everything is under bonds. And they go into that account I was talking about earlier. And they want to keep that. They don't want you to know those bonds are there.
yeah.
Do you know why they put the bonds there? Because what will happen if a prosecutor brings this to trial and you literally have a trust, and you go in there and you prove you have this trust to the prosecutor, he is so dead, so dead. He literally just lost his bond, and you can claim that bond because that's what he's bonding himself against. That he did his research. You do not have a trust. You're an incompetent child that's under guardianship. And if you can prove you're not, he just lost his case. And the whole thing is just thrown away.
Hopefully.
I know people who've gotten it. I've seen cases that have been dismissed for the same reason.
Well, guess what Fearless Floyd's going to do? He's going to bring it to you for real and show you this is the proof of concept. And I'm going to do it not once, but definitely twice, if not more times. Yeah. And I'm going to do it for myself, for my pending parole, as everybody knows. There's no secret there. And I'm going to pop somebody out of prison. And I'm going to show you that they're in prison and pull up their court case and pop them out. Absolutely. Doing this.
Well, you can get that person in prison. You can probably do his paperwork and help him do his paperwork. And he literally has got to get it signed. And there is a notary in prison that can notarize this stuff for him.
Yeah.
And he can assign you, guess what, as the trustee, or he can sign you as the authorized signature on all accounts by filing a 56 form. But I'll get into that on the next one.
Right.
But there is so many different things that this person in incarceration can do to give you the authority to be the beneficiary or even the trustee of the trust, or as an assistant trustee. So you can, as an assistant trustee, you can use the trust in the same way to offset everything because you have the power to do so.
Okay. Yeah, I did his finished up on his direct appeal and then did his state writ of habeas corpus and taught him how to do his federal writ of habeas corpus before they kicked me off that unit and sent me to another one after I terrified him. But yeah, he calls me. You'd be like, call me 11 o'clock at night from the cell phone. Hey man, what's up? Have you figured out how to get me out yet? No, I'm still working on that. You know, nobody can give me proof positive that it works, but you know, you're going to be my guy when I do. So yeah. Okay.
That's what I'm here for, to spread the truth and to show people that it's just smoke and mirrors. It's just like little Toto pulling back the curtain on the wizard. That's all we're doing, is we're pulling back the curtain on the wizard.
Right. Yeah. I call courtrooms three-ring circuses because there's the judge, there's you, and there's your adversary. and all of y'all are putting on the court jester hat, you know, playing your role. Yeah, it's a circus.
Yeah, it sounds like it.
Yeah, here for your entertainment. And that's it. It's a show.
The only judge I ever stood in front of was a juvenile court judge because my daughter violated curfew and she got caught at 10:20 at night getting an ice cream after work before she came home. And I had to go to court for that. And I just was like, I was laughing. I thought it was the most ridiculous thing I ever saw. And this judge is so angry at me. I'm just like, come on, you got to be kidding me. 20 minutes. She just finished work. You know, I was mad. I really was. And the funny thing was, I knew the police officer who picked her up because I worked in their building installing their computer systems. And when he saw me come down there, he says, we don't have any computer problems. I know. I go, yeah, I know, but you do have that little girl over there that's mine and I need to recover her.
Right. Yeah.
Yeah.
Okay. We are almost done, kids. Panel 40.
So recently, this is just kind of a recap. So recently, all the videos that I have been seeing recently are not really concerning the trust and following the rules of trust and equity. People are going into court and claiming it's not my signature, it's not my birth certificate, prove who I am, trying to change their names, trying to claim that they're state nationals, which is a name that doesn't exist because you can't create new names for a state. You know, it's just not possible.
It's actually an oxymoron, like sovereign citizen. When you think about it, state, national, you really can't.
It's a double-edged sword. You're just asking them to open the cell or open the door and just let you walk in. Basically is what it is.
Mhm.
So they're all ended up in jail or thrown out of court. So, I mean, I've seen so many of these state nationals come in. I won my case and the judge is having them literally hauled out of court and they call that a win. They didn't win anything. They just opened themselves up for a world of hurt. But that's another day.
Right. Yeah.
So we can never bring the public or the private into the public when dealing with courts. So when people walk in, oh, I'm the authorized representative of the estate and I'm here to settle the estate. Wrong, guys. You just brought the private into the public. They are gonna wipe your butt across the floor with it. Seriously, they're just gonna, wipe you up with that one. So you can't do it. Okay, there's proper ways to handle all of this, and it's not that difficult if we understand what an offer is, aka court case, to create the trust. It's just understanding what things are. And we just need to keep in mind, all of it deals with signatures. Learning who your signature is, accepting your signature, accepting who you are, accepting you signed it is the number one key. Once you can do that and get out of all this other brainwashing, it's not my signature, it's not my name, it's not my birth certificate, it's not this, it's not that. Get out of it. Use the system in your favor. Quit fighting it. Quit fighting it. And just keep in mind that you signed the paperwork. They can show you that damn piece of paper. And are you going to just sit there and, commit perjury in court saying that's not my signature? It is your signature, sweetie. You signed it. Plain and simple.
Right.
So we just have to understand we're a grantor. As a grantor, we have so much power. So why give it away by saying it's not me? Use the power invested in you as the grantor to create the trust to take care of the business.
Exactly. Yep. I mean, you
The last one is just a summary of what we went over today.
Oh, that's must be like 41 pages long.
I really tried to condense this. Maybe I should have condensed it a little bit more, but it's kind of hard, because there is so much and there's a lot of, misconceptions and misinformation out there. So today we went over what everything we do in a trust and how trusts work, which is very simple. It's not complicated. We create it, we transfer titles into it, and we use that to assign different titles: beneficiary, trustee. We want the trustee to take care of it. Once we claim the offer, create the res, move the res into the trust, creates the equity inside of the trust. We use that equity inside of the trust to give it back to the person who gave it to us and create their trustee title. They need to handle it. They take care of it. So it's very simple. Once you can understand the simple steps that we've just gone through, you can use this on every single thing there is. Okay. And today I talked about setting up your accounts, and you have the funds, which are automatically drawn bank, and get rid of that, guys. Quit having them just tap into your bank account and take your funds out of it. Make them send you the damn bill. Make them give you the coupon. Use that, recover it, throw it into your trust, give it back to them, and then they're responsible for taking care of it. That's it, guys. Those are the basics of trust.
Just that simple.
It's simple.
It took us 2 hours to explain that. So,
Oh, a
I'm,
few mishaps here and there.
I'm kidding. Okay. That's a lot to digest. You're probably gonna have to watch this video several times, multiple times. Hopefully everything was oral and you don't have to visualize it. And you can, do as I do, go to the gym and work out and listen to stuff and learn and program yourself. For some of you guys that are just starting out, I understand this sounds like Chinese or some foreign language, but this is going to be as easy once you learn the process, just like math, how to add, subtract, multiply, divide. Remember how complicated that looked when you were a little kid and, you had a pencil and paper. And then eventually, you were just doing it in your head. And that's what this will evolve to. It took us, for you that are 18 and above, took us 18 years to get miseducated or uneducated. And for some of us, even longer. So don't expect to learn this process and master it in 18 days. Yeah, that's not going to happen. This is something that you're going to have to do yourself. It's going to be trial and error. You're going to have to fall down. You're going to have to crawl. You're going to have to get back up. You're going to have to clean your bloody knees off and keep going and move forward until you do perfect the process and you totally understand exactly what you're doing and how you need to move around in this new realm, which, nobody you talk to, unless they're like us, enlightened, you're going to be able to communicate with those people because they're indoctrined in their institutionalization and programming of their public education or the mass media that they watch on TV. And that's a sad commentary on the world in a whole, that we continue to allow this to happen to the children of the world, to be brought up and educated in a dysmorphic way, as simple as I can put it. we should all be teaching our kids, law, UCC, trust, how to operate from a young age. If we could go back and do it all again, that's what we should do. Thankfully, I'm blessed with a beautiful and highly intelligent daughter who's smart, way smarter than I am. Yeah, who's getting her PhD at SMU. And she'll grasp this very easily and quickly once I'm able to sit down and spend time with her to break it down, or she has time to watch videos.
Guess what? The hardest part is creating the trust. All you basically have to do is create your trust first. Okay. Do your address change, write your documents, create your trust. After that, every single offer is only done as transfer and assign, transfer and assign, transfer and assign. And that's all you are going to be doing from now on. Once your trust is there, you're going to take the offer that comes in the mail. You're going to transfer titles to the trust, and then you're going to assign the titles. You're going to assign them to the trustee.
Yeah.
So once you get that down and you got your trust, then all you have to do is understand transfer and assign, and your whole world will change completely.
Okay, kids, you heard it first. The first thing that you should do is establish your trust. Take everything else, push it out of the way. You don't need to do your UCC 1, your 4 horsemen security agreement and hold harmless indemnity agreement. Just set that aside. Even doing your name change, set that aside. So if you want to jump on here and you have something lingering in your life that you want to take care of, whether that looks like a court case, child support, foreclosure, mortgage, car loan, bills, everyday life, traffic tickets, whatever. I'm not going to say this is the path for you, but it is a path that offers you an opportunity to master, perfect, and operate in society. So we're going to leave it at there. You want to do this again tomorrow around the same time?
Let me get back with you on that one,
Absolutely.
and see if I can finish up the second, segment
Okay.
today. Because the second segment, I want to try to cut it down a little bit and only talk about signatures and how important your signature is and how you sign. Because that's really important in trust, and it's really important in grantors and how you sign your signature on every single thing.
Okay. Yeah, that's fine. I'm going to send you my phone number because apparently you don't have.
I live in Tahiti. I can only call on FaceTime
Oh,
or on
okay.
Telegram.
Okay, that's fine.
Otherwise, it's like $12 or $14 a minute.
Oh, great.
Yeah.
Yeah, I don't get email notifications, so when you email me, I don't get it right away. That's all.
Oh, okay.
Yeah. I was just trying to think about a more instantaneous way of communication, whatever that looks like, but I'm good with that.
I guess on your chat, I could say, sent you a DM.
Yeah, you can do that because I check that periodically. I try to turn off all notifications because I'm in a member so many groups. My phone's like ding, 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 ding. It never stops.
Oh, I've done that too. I totally have done that.
Yeah, I have a friend.
I can't stand watching these things pile up on my computer all day long.
Yeah, I can't either. I've got to get rid of all.
I've muted them all. I've
I
muted
don't-
everything.
Yeah, I don't know if it's ADHD or what it is, but I don't like those. So-
No, it's annoying. It really is
Right.
annoying when you're thinking of something and you hear bing, 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 bing.
Yeah.
Oh,
Okay. We'll contact tomorrow.
okay.
Okay. Yeah.
Or later on this afternoon, I can,
That's fine.
It shouldn't take me much longer because I've got about half of it finished. Shouldn't take me that much longer to finish up the rest.
Okay, even if you don't have that one video, or have that material completed, we can do another topic, no big deal. I just
Okay.
like to get kind of in a groove to where we're churning these out regularly, and that way we'll starting to have people follow us and ask questions they can keep up.
Okay, we have the one I did on bonds because bonds and trust are interchangeable.
Right.
Yeah, I did send you some different ones on email,
Right.
different types of, information and things that have led me to where I am right now.
Right. Okay. Hey,
Yeah.
I'm guilty. I'm a procrastinator. I will start a series and abandon it. And it's not, a deliberate thing. I'm a Gemini, so I have like 40 different things.
Oh, I'm a Taurus. I just bull my way through.
Yeah. I mean, I've got like an unfinished painting right here and, just like I said, stacks of stuff everywhere that I need to do. So, yeah. But,
I like order.
it's in order, but it looks like chaos. It's orderly chaos. Absolutely. Okay. Again, thank you very much, Ann, for your grace, your honor, your intelligence. You're putting this together, your time and energy. Unbelievable. Everybody, like the video if you like it. Leave a comment below. Tell Ann how much you appreciate what she's doing for us. And I'll talk to you tomorrow. Have a good evening. For everybody else out there, you know what to do. Like, subscribe, share, hit the notification. Fearless Floyd Show on Telegram, yahoo.com for the email, Rumble, BitChute, and YouTube as you're probably watching. And with that, anything else you'd like to add in closing?
No, but thank you for inviting me and thank you for allowing me the opportunity to spread the truth and what is happening right now, because there's so much misinformation that I'm just sort of burnt out seeing it. I'm tired of reading it. And I just think people need to understand the truth and understand who they are and get out of this mindset. So they went from one programming into a different programming, telling everybody their status, standing in character. And now they've got them into this mode of programming. And now we've got to get them into the correct mode of programming, which you're just an inhabitant. That's all you are. You're an inhabitant of the world. You own no property because the earth's property is owned by God. You are here as a trustee, as an estate, to take care of the estate, to take care of the land, to pass it on to the next generation. God owns everything, you guys. You don't own it. So all this thing about giving back my land titles, you own the structure that's sitting on God's land. You can own that, but the land that sits on is owned by God. It's given to us in a trust to take care of it. That's it.
Absolutely. Or it'll take care of us.
Yeah.
Literally.
And just remember, your energy is your equity.
Yeah, absolutely. Yeah. Okay, Ann, thank you. Have a good night, everybody.
Thank you so much.
Here, appreciate it.
Bye.
Good night.